The most common challenges during probate include undue influence and lack of capacity to change their estate plan. A will can be contested during probate by someone with standing, usually an heir or someone listed in the will, coming and filing an objection to the proceeding. If the estate is insolvent, it can present some issues. Oftentimes there's assets that need to be handled, but the only way to get someone the authority to do that is through probate. So even if the estate is insolvent, we may still be needing to go through the probate process. Disputes between heirs do happen during probate. Those oftentimes are related to how a representative handles assets. Another heir may think that the representative is mismanaging funds, or that the person who wrote the will didn't know or understand what they were writing, or maybe didn't really want the will to say what it ended up saying. We also see where heirs can be upset and think that the person didn't have the mental capacity to update their will. That capacity is called testamentary capacity. If someone doesn't have testamentary capacity, they're not able to update their will. In Utah, testamentary capacity is a really low bar, and it's pretty easy to show that someone has testamentary capacity. If the executor is uncooperative, we recommend that you probably hire an attorney to represent your interests. The attorney can reach out to the executor or the executor's attorney and ask for copies of account statements, any applicable legal documents, and get a feel for what's going on in the probate process. Probate can be expensive and time-consuming and heartbreaking. It can pull families apart, and usually no one is left satisfied. We recommend being really careful in who you pick to be in charge of your estate to try and reduce the chance of having these probate issues. If you have questions about common probate challenges, give us a call at ProvenLaw.